do an introduction of our speaker, Dr. Dana Thompson Dorsey. Dr. Thompson Dorsey is currently an associate professor of educational leadership and policy studies at the University of South Florida. Her research and teaching focuses on educational law and policy issues, as well as critical race studies. And specifically, her research critically examines federal, state, and local education laws and policies, as well as pre-K through 20 school and university practices. Her research focuses primarily on issues related to school segregation, school discipline, the school-to-prison pipeline, race-based admissions policies in higher education, school choice policies, as well as implicit bias, and culturally responsive school policies and practices. She has been published in numerous leading educational journals, such as Teachers College Record, Educational Administration Quarterly, Peabody Journal of Education and Educational Policy, and currently serves as the co-editor for Educational Researcher. She received a PhD in education from the University of Pittsburgh School of Education, with concentrations in social and comparative analysis in education and policy studies. Additionally, she earned a JD from the University of Pittsburgh School of Law and a BS in accounting from the Lincoln University of Pennsylvania. And prior to working in academia, Dr. Thompson Dorsey was a practicing attorney specializing in employment discrimination and civil rights litigation. So thank you so much again, Dr. Thompson Dorsey, for being here. And I will turn the floor over to you.
Well, thank you so much. And thank you, Dr. Conner, for inviting me. You didn't have to really convince me too much to stay because, you know, this is home. I'm born and raised in Pittsburgh. And actually, before I came to USF 4 years ago, I was at the University of Pittsburgh as a professor and also the associate director of the Center for Urban Education. So I was pleased to say yes. I would love to be able to talk with the faculty in the School of Social Work. So thank you for having me, and thank you for joining us virtually. And I'm happy that everyone is safe, hopefully in their homes and away from all this snow, which I don't miss, and the cold I don't miss. But it does make me really feel like I'm home. So thank you. So as Dr. Conner mentioned, I'm going to talk a little bit about the history of affirmative action, particularly race-conscious affirmative action in this country, and talk about the future, given the Supreme Court's decision in SFFA, which is the Students for Fair Admissions versus Harvard and UNC. So let's see. Just to get us started, I am going to, and I know you all can read this as well on your own, but I'm going to read this just for impact purposes. And what I'm reading here is this introduction comes from Justice Ketanji Brown Jackson's dissent in the SFFA UNC decision. She did not take part in the Harvard decision because she recused herself because of her relationship with Harvard. So this hypothetical is specific to UNC. So John and James are both North Carolina residents who can trace their family history to the founding of UNC in 1789. And UNC is the oldest public university in the country. Okay, if admitted, John would be the 7th generation college student to attend UNC. James would be the first to attend UNC as a college student, even though his enslaved ancestors built the university and many generations of family members worked as laborers. Laborers and staff. John and James are not responsible for their race or family's history at UNC, yet they have been impacted by both. Then she moves on with this very nice historical analysis. Most likely 7 generations ago, when John's family was building its knowledge base and wealth potential on the university's campus, James's family was enslaved and laboring in North Carolina's fields. 6 generations ago, the North Carolina Redeemers aimed to nullify the results of the Civil War through terror and violence. marauding in hopes of excluding all who looked like James from equal citizenship. 5 generations ago, the North Carolina Red Shirts finished the job. 4 and 3 generations ago, Jim Crow was so entrenched in the state of North Carolina that UNC enforced its own Jim Crow regulations. 2 generations ago, North Carolina's governor still railed against integration for integration's sake, and UNC Black enrollment was minuscule. So, at bare minimum, 1 generation ago, James's family was so behind. Six generations behind because of their race, making John's 6 generations ahead. To demand that colleges ignore race in today's admissions practices and thus disregard the fact that racial disparities may have mattered for where some applicants find themselves today is not only an affront to the dignity of those students for whom race matters, it also condemns our society to never escape the past that explains how and why race matters to the very concept of who merits admission, permitting, not requiring, colleges like UNC to assess merit fully without blinders on, plainly advances, not thwarts, the 14th Amendment's core promise. UNC considers race as one of many factors in order to best assess the entire unique import of John's and James's individual lives and inheritance on an equal basis. So I want us to keep this part of Justice Brown Jackson's dissent in our minds as we go through history and talk about affirmative action. So just as a background of where we are today, affirmative action policies, have been highly contentious, divisive, volatile, legal and political debate for over 50 years, pretty much since they went into effect after the Civil Rights Act of 1964. And for those who are supporters of the policies, think it's necessary in order to fulfill the original intent of affirmative action, of bringing about equitable and equal educational access and opportunities for students, namely students of color who have been traditionally and historically and continue to be disenfranchised. But those who have been opponents of the policies say that giving preferential treatment to students based on race is completely unconstitutional and violative of the 14th Amendment and Civil Rights Act of 1964. Since the early 70s, we have had 7 United States Supreme Court cases. Since the mid-1990s, we have had 9 states, and you can see them listed here, that have banned affirmative action, either through a ballot initiative where the voters voted for it, or the governor's executive order. There have been significant drops in applications and matriculation of underrepresented students of color and in the state institutions. Now, the only state that says they have not had significant drops has been Oklahoma, but I'm thinking it's because it's Oklahoma. They've never had a very large percentage of underrepresented students, particularly Black and Brown students. But California was the first state to actually ban affirmative action in 1996. And they reported they had a 40% drop in applications after they banned it. And they have since struggled, particularly at their top elite, UC institutions such as Berkeley and UCLA, in getting those numbers back to where they were prior to 1996. And so they still have some race-based admission policies in place without really going against the ban, but it's been a struggle. Now, the cases with Harvard and UNC Chapel Hill, which both get a tremendous amount of applications, particularly in their freshman year. And in fact, when this case began around 2015, UNC Chapel Hill had received more applications for incoming freshmen than Harvard. And from the time that case began, they have seen a continuous drop in applications from Black and brown students particularly. And so a book that was written in 1998 by Bowen and Bach called The Shape of the River, that talks about race-based admissions and the competition that occurs. They talk about how it's not really about fairness. It really comes down to this. In colleges and professional schools that admit nearly every qualified applicant, there is little to debate. It is when there are strict limits on the number of places in the entering class and far more qualified applicants than places that the choices become difficult and the issue of race comes to the forefront. Not gender, not sexual orientation, not anything like that. Race. Excuse me for a moment. I'm sorry. My phone is ringing and I want to turn. Sorry about that. Thought I had turned my ringer off, but obviously I did not. So please excuse me for that. Okay. So affirmative action actually comes out an old English concept, because being as though, you know, the United States, it came from people who originated in Britain. They, of course, brought about English law when they came into the United States. So it does mean that it's a concept of equality, and it's the administration of justice based on fairness. The first time affirmative action was used was not in the 1960s, as most people think. It was actually used the first time in 1935 as part of the National Labor Relations Act, also called the Wagner Act. Employers could not discriminate against union members, affirmatively had to act to make victims whole. Now, these were not dealing with people of color because they were not allowed to be part of the labor relations union. So it was really dealing with those who were discriminated a lot during that time, those who may be Irish or Italian, or if women, in fact, were working. So that's more about what that law was about. Then in 1941, you had Franklin D. Roosevelt, who had an executive order that banned racial discrimination in government and in government employment and defense, and during the defense industry in terms of working the production lines during World War II. Now, of course, during that time, you needed as many people working as possible. You had civil rights leaders that were arguing that people of color and women should be able to work on the production lines. And so that's why Franklin Roosevelt passed his executive order to address affirmative action, but he didn't desegregate the military, right? So didn't really mean that much. It still was sort of interest convergence because of how they needed the workers. So now I want to step back, though. We know that affirmative action was used in those early years in the 30s and 40s, and then we'll, after we talk about history, we'll jump to the 60s and current. But the actual history or historical context of race-based policies go way back. And so we're going to begin with our founding documents, our Declaration of Independence and our United States Constitution. And in the words of many of the legal cases that were coming through, particularly for slaves that were suing with asking for freedom or other issues that came up in terms of what race someone may be considered, what was generally the belief of Supreme Court justices and judges was that the words in the Declaration of Independence and United States Constitution were not written to include people of color, particularly Black or African-American or Indigenous people. They were deemed as savages, beasts, animals, and of course for Black, those who were African, they were property. And in Article 1, sections 2 through 9 of the US Constitution, you won't see it there now, but it was there for a very long time, that enslaved Blacks were only 3/5 of a white person. Slave owners would be apportioned only 3/5 per slave for tax purposes. And, so it basically was helpful in terms of helping, I guess, for taxes, right? But it also was helpful in terms of also thinking about land. So once again, interest convergence, it was helpful because really they weren't even considered human. Enslaved Blacks were property. But they were, at least as it was helpful to white plantation owners, 3/5 of a white person. And then we go to Dred Scott v. Sanford, where you had a man who, Dred Scott, who was enslaved and escaped to a free state in Illinois. And he went back actually to the place where he was enslaved, but was expecting to be free. And mainly he did that because of the slave owner who actually owned him and was going to free him anyway, asked him to come back and work for a wage. But when he came back and his slave owner passed away, he was enslaved again. So he sued because he said, I'm free. Once I went to a free state, I'm officially considered free. And it made it to the Supreme Court. And the question before the court is, can a Negro whose ancestors were imported into this country and sold as slaves become a member of the political community formed and brought into existence by the Constitution of the United States, and as such, become entitled to all the rights and privileges and immunities guaranteed by that instrument to the citizen? And in short answer, Justice Taney said, absolutely not. No, no, and more no. And so this actually became an impetus to the Civil War. But what is important to our discussion is what Justice Taney said in his decision. In the opinion of the court, the legislation and histories of the time and the language used in the Declaration of Independence show that neither the class of persons who have been imported as slaves nor their descendants, whether they had become free or not, were then acknowledged as a part of the people, nor intended to be included in the general words used in that memorable document. Or when the Constitution was framed and adopted, Negroes had for more than a century before been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect. So we have the Civil War, right, which was not about a battle of state rights. It was all about slavery because you had the southern states that had seceded from the northern states because they wanted to maintain slavery and continue to build their economy and grow their land, expand their land on the backs, blood, sweat, and tears of enslaved Black people. That was the reason for the Civil War. But after hundreds of thousands of people were killed, including enslaved Blacks who chose to fight in the Civil War, you had the Emancipation Proclamation. And as many of us know, the last of those were not freed until in Galveston, Texas, until June 19th of 1965. So that's the official end of slavery. You had the passing of the 13th Amendment ratified and slavery was abolished. But you also had the Freedmen's Bureau, and they were put in place by Congress, the Freedmen's Bureau, to actually bring about legislation to help those who were newly freed Black people who were formerly enslaved to get on their feet, right? basically so they would not be a drain on the resources of society. But many of those who were really responsible for making sure that Freedmen's Bureau legislation would pass were Northerners. And so, but there were several iterations of the act. The first one, written in 1864, promised that newly freed slaves would get an education, would receive land and farms, would be protected by labor regulations, would receive medical assistance for children who were orphans because their enslaved parents were murdered or separated from them and they couldn't be found, would also receive aid. But many of the congressmen opposed that, not just the ones in the South, but many of those even in the North. And it was because they say why the freedmen of African descent should become these marked objects of special legislation to the detriment of the unfortunate whites. So basically, the Freedmen's Bureau Act, right, 1864, arguably first affirmative action pieces of legislation. So then you had your 1865 and your 1866 amendments to the act. And they actually primarily benefited white refugees from the Confederate States. Now, General Howard and so many of the others, more Northern legislators, had a real problem with this because that was not the purpose of the Freedmen's Bureau Act. And General Howard basically said, look, education is absolutely essential to the freedmen to fit them for their new duties and responsibilities. Yet I believe the majority of white people to be utterly opposed to even educating the Negroes, because at this point, all of what was promised had been stripped away. They refused to fund, the Congress refused to fund all of these things for Black people. The money they had went to white refugees. So what was left by the 1866 amendment was only education. Now, I'm sure many of you are familiar with the term 40 acres and a mule. That came from the Freedmen's Bureau Act of 1864. We never saw any of that. We had Black codes in 1865 as well. So you still had Black people that were being tortured and lynched and having to follow these ridiculous laws where they had to be in the house before sundown or they would be imprisoned or murdered. So the Civil Rights Act of 1866 was supposed to legally overturn Black codes, but it still was happening. But the language in the Civil Rights Act of 1866, which became the template for what we know as the 14th Amendment, particularly the Equal Protection Clause, stated that all citizens of the United States of every race and color should have the right to full and equal benefits of laws and proceedings for the security of persons and property. So you can't just throw Black people in prison. You can't just murder them because they're on the streets or they're on their way to work. And it was particularly, pretty much only written because of what was happening to newly freed slaves, okay? But President Andrew Johnson vetoed this law and said, in all our history, no such system as that contemplated by the details of this bill has ever before been proposed or adopted. The distinction of race and color is by the bill made to operate in favor of the colored and against the white race. But Congress overrode the veto and they were able to authorize and ratify the Civil Rights Act of 1866. And as I mentioned, that was really the beginning of the writing of the 14th Amendment of the United States Constitution, which was ratified to protect freed Black slaves or newly free slaves from racial discrimination and unfair treatment. But it is now being weaponized, the 14th Amendment, along with the Civil Rights Act of 1866, we'll talk about that later, against people of color in affirmative action cases. And just a little note, the 14th Amendment, Section 3, given that the template is the Civil Rights Act of 1866, that section says anyone who has been involved in an insurrection shall not serve in any elected position, because all of these people in the South, those who still want to secede, who still want slavery, who still want to murder and lynch Black people, should not be serving in office. So think about that when you're thinking about Donald Trump. And because the Supreme Court's about to hear whether Section 3 applies to him on February 8th. And it does, just to let you know. Okay, now we're going to jump forward to present day. Affirmative action was named, or really coined as a term, by John F. Kennedy. In the 1961 executive order, he directed contractors on projects funded with federal money to take affirmative action to ensure that applicants are employed and employees are treated during their employment without regard to race, creed, color, or national origin. It also established the EEOC and laid the groundwork for the Civil Rights Act of 1964. President Kennedy said, we need a Civil Rights Act that does not merely eradicate discrimination, but eradicates oppressive economic and social burdens imposed on Black people due to racial discrimination. And look, we're almost 100 years from when the Civil Rights Act of 1866 was passed and still talking about the same thing, right? It was also meant to expand educational and employment opportunities. But President Kennedy, was murdered. And so 5 days after his death, then President Lyndon Johnson and several civil rights activists, such as Reverend Dr. Martin Luther King Jr. and some members of Congress, worked to pass that Civil Rights Act of 1964 and got it passed in July of 1964. And the key provisions of that, most people know about Title VII, but that deals with employment. But Title VI of the Civil Rights Act of 1964, which is applicable to all institutions, if you receive federal money and you are discriminating against people based on race, color, creed, national origin, religion, sex, you will lose that federal funding. And most institutions, particularly public institutions, could not afford to do that. And what's also important is the Civil Rights Act was applicable to private institutions as well. So that's why restaurants, hotels, all of that had to, of course, desegregate, get rid of racial discrimination. 14th Amendment was applicable to public institutions. All right, so I want to talk to you as we move into actually talking about the case itself, give you some of the legal background so you understand some of the language you may have heard as you were listening to the Supreme Court's decision in the SFFA case. So there are 3 levels of scrutiny when the court is hearing cases that they follow. The highest level is called strict scrutiny. And it's a very, very hard bar to reach. And what falls under strict scrutiny is race, anything dealing with race, what they call a suspect class, and anything dealing with our fundamental rights. So if you're talking about freedom of speech, freedom of religion, the right to bear arms, basically anything that falls in the Bill of Rights, those first 10 amendments will be under strict scrutiny. So, of course, these race-based admissions policies fall under strict scrutiny. And the 2 questions that have to be answered, and in this order, are whether the racial classification is used to further compelling governmental interest, and whether the government's use of race is narrowly tailored, meaning it's necessary to achieve that interest. Now, outside of university admissions cases, the United States Supreme Court had only identified 2 compelling interests that could actually meet strict scrutiny, and that was remediating specific identified instances of past discrimination that violated the U.S. Constitution or a statute. And so you think about like de jure versus de facto, segregation, which was the issue under Brown v. Board of Education and Jim Crow laws. That was de jure versus de facto segregation is people make the choice to segregate themselves, such as where we see where people live, right? But that's not illegal. The other was avoiding imminent and serious risk to human safety in prison, such as race riots. Most people don't know about that, but that's also when it's a compelling interest. Now, when you're talking about universities' admission standards since the 1970s and until the SFFA case, this is basically the law. You cannot use quotas or set-asides, meaning you can't say, I'm going to set aside 20 seats for Black and Brown, or Native American students to enter the law school, the medical school, the School of Social Work. But universities had to show that there is an educational benefit to diversity, and they have to show that it's actually a compelling state interest. That's become known as a diversity rationale, and that came out of the Bakke case in 1978. And they also had to show that the policy that was narrowly tailored, and that basically means it was specifically written to the issues they're trying to address in terms of diversity. And that had to include an individualized, holistic review of each person's application, regardless of race, to achieve a critical mass of underrepresented racial and ethnic minorities. That critical mass, this language came out of Grutter v. Bollinger, which is a case out of 2003. And race could only be used as a plus factor. It could not be the factor for admitting students. Now, this is the decision. I'm making it very simple and getting to the key points because it's 100 and something pages. And I'm sure you haven't read the opinion. So the court said that both the race-based admission policies of Harvard and UNC were unconstitutional and violated the Equal Protection Clause of the 14th Amendment. Now, they got to that decision by saying that the purpose of the Equal Protection Clause, as well as Brown v. Board of Education, needs to be fully realized. So they understand why the policies existed. It's meant to eliminate racial discrimination. But there had to be an endpoint at some point. It couldn't just go on indefinitely. And in the Grutter case in 2003, Justice O'Connor, Sandra Day O'Connor, who recently passed away, wrote that decision. And towards the end of the decision, she put a 25-year endpoint to that, which would basically be 2028. So with the court we have now, they were bound to find it unconstitutional. They decided to do it 5 years early, which is not a surprise. The court also said universities' race-based admission policies do not meet strict scrutiny. It didn't meet that high bar. And you cannot measure how race-based diversity results from training future leaders, acquiring new knowledge based on diverse outlooks, promoting a robust marketplace of ideas, and preparing engaged and productive citizens is really a compelling reason to want diversity. That sounds good. We know that you mean well, but it doesn't meet strict scrutiny in terms of being a compelling state interest. It sounds like it should be, but it's not, according to the court. Admissions programs fail to articulate a meaningful connection between the means they employ and their goals. So the policies of trying to achieve those things I just talked about, that were their goals, but how they were going about it just didn't cut it. And they really had an issue with racial categories. And Dr. Conner and I, when she moderated the session, the all-angle session yesterday, I guess because I won't say my opponent, my partner in this discussion talked a lot about these racial categories and affirmative action. So basically there was this concern because it was Asian students that were suing these institutions, and they were the SFFA group. And there was this concern that the Asian and Asian American category was way too broad. How you can say South Asian and East Asian students fall under the same category of just being the same category, have the same background of just being Asian. And they also talked about all of these arbitrary categories, such as Hispanic and so on and so forth, Middle Eastern students, and even those who would be considered Black versus African American versus African, all too broad, right? And these were categories that were created in 1978. But I will say, no, yeah, these specific categories were created in 1978, but it was white men in the 16th and 17th century who wanted to make sure that the poor planters elite, that poor planters who were not elite, who were poor, were white, who were partnering with slaves, indentured servants who were Black and white, and some of the Black indentured servants were free. And Native Americans, they were fighting these rich white plantation owners. And many oftentimes getting slaughtered, but they wouldn't give up. It went on for years. And basically you had these rich white plantation owners go back to King George and say, what do we need? What are we going to do? We can't make money this way. And he said, well, pit them against each other. And that's how that racial hierarchy began, of calling them white and Black and all of that. So these racial categories, while the Supreme Court says they're arbitrary, undefined, too broad, they created them. Now, the last thing they said was universities use race negatively and engage in stereotype and engages in racial balancing, which they called a zero-sum game. And once again, okay, we get that race can be used negatively and engaged in stereotyping, but once again, it's not because of people of color. They don't necessarily engage in the stereotyping. And if they do, it comes from implicit bias, which once again comes from white people over hundreds of years. But all of that's unconstitutional for these reasons. So once again, sort of blaming the victim. Justice Roberts did acknowledge, though, that while they found these policies to be unconstitutional, what they do not have a problem with, and this is very important for you all to think about, right, as social workers, and particularly as you work with communities and those who work in schools, that students can still talk about their experiences with race and racism in their personal statements. They can talk about different barriers they've overcome, obstacles they've overcome due to discrimination or due to experiences that even their parents have had, maybe not getting a college education or having access to certain employment opportunities because of racism and discrimination, and how that impacted them. So students can still talk in their own words, and admissions departments can still consider this. That is still allowed. So I mentioned earlier how now the 14th Amendment Equal Protection Clause and Civil Rights Act of 1964 is now used against people of color, right? And so this shows it, as Justice Roberts, in his opinion, talks about the purpose of the 14th Amendment and what it was for, right? And he even goes as far as to quote then President Garfield. At the time, it was ratified in 1868, he was president. And President Garfield said the 14th Amendment would hold over every American citizen without regard to color, the protecting shield of law. And Senator Howard, during that time, who was also, that's the one who made sure students, Black people had an education, had funding for that, that the amendment would give to the humblest, the poorest, the most despised of the race, the same rights and the same protection before the law as it gives to the most powerful and most wealthy or the most haughty. For without this principle of equal justice, there is no Republican government and none that is really worth maintaining. Well, That sounds good. But here we are, 250 years, almost 250 years after slavery was abolished, 156 years after the ratification of the 14th Amendment, almost 70 years since Brown v. Board of Education, as well as 60 years is the passage of the Civil Rights of 1964 and Voting Rights Act of 1965. And we're still dealing with racial disparities and structural racism in every aspect of democratic society. So let's talk about that in terms of the wealth gap. So the Federal Reserve put out a report in October last year saying that the typical white family had about 6 times as much wealth as the typical Black family, 5 times as much wealth as the typical Hispanic family. And these ratios have narrowed since 2019 as non-white home, stock, business ownership all increased relatively more than for whites. And that makes perfect sense because the 2020 census told us that the white population of those who checked that box was at a negative 1%, has dropped. But Black, Latino, Asian, they have increased exponentially, well, particularly Latinx and the Asian population. So that makes sense, but there's still that gap. But this is what's really eye-opening, is the Black-white wealth gap. RAND did a study and published it in 2023. The median Black household in America has around $24,000 in savings, investments, home equity, and other elements of wealth. The median white household, $189,000. The median wealth gap in America between the middle income Black and middle income white households is around $164,000, but the average wealth gap is around $840,000. Researchers, in addition to RAND, found it would take $7.5 trillion to bring that wealth gap to half between Blacks and whites, and $15 trillion to eliminate it completely. Other studies over the past several decades have estimated what a fair reparations program would do. And California is doing a study on one now, and calculated that unpaid labor of enslaved people at 24 hours a day was worth $14.2 trillion in today's dollars. And that doesn't include psychological harm that, of course, enslaved people experienced. And the Roosevelt Institute estimates that if freed slaves had received their 40 acres and a mule, that would now have generated an economic return worth $16.5 trillion today. In other words, there would be no wealth gap. So let's go back to Justice Brown's example. Just ask you to think about it in the back of your head and, breathe through it pretty quickly. And think about that wealth gap. Think about these generations, these different experiences, who had access, who didn't. Think about where we are and think about that SFFA versus Harvard and UNC decision. Who do you think benefited from race-based admissions? Which racial ethnic groups have benefited the most from race-based affirmative action, laws and policies and practices? And that's where I end, and would love for us to have a discussion on that.
Thank you so much. That was a whole lot of information. And I thank you for having that wealth of history and context, because I think for many of us, we have a much more greater understanding of sort of modern day affirmative action, and yet don't understand the history and the context where some of this has come from. Before we go into that, I already saw some hands go up, so I know we have questions from the audience. I wonder if you might be willing to talk about that last question really quickly, and then we can maybe open it up and start the discussion early. But I want to make sure that we get on record here. One of the things that I learned, and that I'd love for you to speak more to at our conversation yesterday, was that affirmative action may not have actually met the goals that it was intended to attain. That while in theory, affirmative action was put in place in its more modern form, in an effort to try to reduce these sort of equity gaps, in particular for Black folks and those who were the descendants of slaves in this country, but that group may not have actually been the group who benefited most from this policy.
Right.
And that even if, for example, the Supreme Court had not decided to place this ban on affirmative action, we still actually weren't seeing the group that it was intended to support benefit from it in the way that I think many of us thought that it was. So could you speak to that a little bit about the goals of affirmative action, whether or not they actually were being met, and who did benefit from it most?
Mm-hmm. Yeah. So no, they haven't been met, as we see in terms of the wealth gap. And many argue, in fact, I believe Professor Bernstein continuously mentioned that it was meant to benefit those who were descendants of slaves. And I would say, okay, arguably, yes, especially since if we go back to that historical context and we go back to the particular laws that were written, the Freedmen's Bureau Act, the Civil Rights Act of 1866, the 14th Amendment, yes, that's who was supposed to benefit, because those who were Black people in the United States at that time were descendants of slaves. But the disparities that we see that occur where Black people are still on the bottom, it's because they have Black skin. They have dark skin. And they may not have been maybe what you would call a direct descendants of slaves, but everybody are descendants of slaves, because mankind began in Africa. Now, so you can say, okay, it was originally meant to help those who were descendants of slaves, but because it is people with Black skin who constantly, or brown skin, just darker skin, and I'm not just talking about in the United States, I'm talking about around the world, who experience persecution and discrimination on a regular basis. All the indicators in the US, Black people, even those who are considered middle or upper class, are always on the bottom, whether you're talking about wealth, whether you're talking about pay in terms of what they're paid, even if you're some executive somewhere and consider yourself wealthy or, upper middle class, you're still not getting paid as much as your white counterparts. If you talk about the opportunity gap in schools, if you talk about maternal death and fetal death rates, many of us know what happened to Serena Williams, who almost died after her first child was born because her doctor wouldn't listen to her and take her seriously when she said she wasn't feeling well, right? Because Black women can just deal with pain. So just deal with it. She almost died. And we did have the young lady who was a champion runner, Olympic runner, who did die. She did die. She was complaining as well during her pregnancy, dealing with eclampsia. They ignored her and she died at her house by herself. And so these indicators, it doesn't matter if they're direct descendants or you can show your lineage specifically, they have brown skin. So that's who it's supposed to benefit, because that's who experiences the disparities and discrimination. And it has not. It is white people who has greatly benefited, as we saw from the Freedmen's Bureau Act. It was white refugees who were part of the Confederacy who benefited, and Congress still was willing to give them the money over Black people, newly freed slaves. All we got was education, and that was even inferior. So here we are.
Thank you for that. The last question that I want to ask so that I can make sure that we get this on the recording before we stop recording and allow others to chime in and speak freely. I know one of the things that I think is, an issue that's particularly important to social work, but also to all of us as educators, is sort of where we go from here. I don't know if you could speak to your understanding of how different universities are adapting their admission policies since the ruling on affirmative action. Maybe there are differences in how this is being handled. And I think that leads into a larger question of, what should we be doing now as social workers? How can we continue to address inequities in higher education in the absence of being able to use race-conscious admissions policies?
Right. So universities are struggling to determine what they can do. They're like, we don't know what to do. We don't know how to deal with this. And I think it really comes down to the seriousness of these institutions, the administrators of these institutions, the deans, provosts, the chancellors, vice chancellors, those who make the policies. If you understand history, which I was trying to share just a little bit in terms of the context for affirmative action, but we know there's a long history in this country. And regardless of what we have, a lot of conservative legislators and governor, particularly Florida's Governor DeSantis, saying that this history is great and, we don't have any issues and there's no racism and discrimination anymore. There's just this indoctrination, people trying to tell us there is. No, there is. There is. And numbers don't lie. All the stats say it. And I think university administrators need to accept that fact. And they need to understand those disparities still exist because the country was founded on white supremacy, patriarchy, and capitalism. And to keep those things going, got to keep white men in power, right? And that is what and it's not even, if we are paying attention to even those candidates who are running for the Republican nominations, if we listen to the rhetoric of conservatives on, conservative media and TV stations, they're clear on that. We got to have power. We got to maintain power. That's why there's been this attack on critical race theory. So when we accept, as administrators, I'm not saying we because I'm not, when administrators at higher ed institutions accept that there is an all-out war to maintain that power, the disparities are going to get worse. And we need to be affirmative in our actions to make sure that doesn't happen. Then that's the only way they're going to actually be able to come up with policies that will work, that are legal. And I will say, there are ways to do this.